Okay, good morning, fellow friends of privacy. Welcome to our DataGuard masterclass. Um, a very interesting topic today, pay to the test. So the practical tips from the authorities on proper consent management. I mean, the topic of pay or consent or pure subscription models, however you want to name it, is currently one of the hottest topics in European data protection, and initiated by the supervisory authorities from Norway, from Hamburg, and from the Netherlands to achieve a binding decision by the European Data Protection Board. I mean, this topic is the subject of much discussion, and hopefully we will have a lot of fun and a lot of discussion here. And speaking about here, one of the initiators of this binding decision that's soon to come is here with us today. I'm very glad that he made the time to join us. It's Tobias Judin. He's the head of international at the Datatilsynet, the Norwegian Data Protection Authority. Good morning and welcome, Tobias. Thanks for joining us.
Like me.
Okay. And yeah, as I said, a very controversial topic, and I hope you will be kind of engaging as well, because Tobias and I try to do so, giving you the latest insights and also breaking down what this topic is about. Just some rules of housekeeping. Due to privacy reasons, you cannot see yourself or the other participants, so just Tobias and myself, and also cannot speak up. But if you have questions, and please do so and raise them, put them in the chat, and we will ensure to address them later. And you will get the slides. We have prepared a few slides for you, but it shouldn't be a slide battle. We want to have this very conversational, so you get the most out of it, but you get the slides afterwards. So that's not a question you need to ask. You will get them. And yeah, without further ado, Tobias, you said European data protection law is said to be currently facing a huge fork in the road. I think that I read that from you. And even if one does not follow the excitement we do, it's easy to see that the authorities are faced with an important decision. You know, the restrictive interpretation of European data protection law and new digital regulation is not just the GDPR, advocated by the European data protection authorities on the one hand, but also the European Court of Justice required the digital company Meta, as others also before, to deploy a pay or consent model in order to ensure freely given and valid consent, and at the same time safeguard the viability of its business model. And as of November last year, Meta has no longer offered the social network service Facebook for free of charge, so to speak, exclusively, but has also offered a parallel pay model that provides for a monetary price for the use of the social network. And it also eliminates the use of data for advertising and will therefore not show advertisements if you subscribe to this model. And the introduction of this model, pay or K, is way older. The Austrian newspaper Der Standard has introduced it many years ago, but the social network doing so has resulted in European data protection authorities, raising the question that go to the heart of data protection law, its ethical and dogmatic core and essence, and that's why we here. And I think maybe not all of you are familiar with the pay or consent model. That's why Tobias and I want to start showing you some examples. So you will see some different models and then get to learn what is pay or K about before we start, the nitty-gritty discussions about what is free consent, what is a fair price, and where does the European Data Protection Board stand with its current draft. So I brought with you several examples, and first one, and bear with me, we are heavily using that in Germany, and I couldn't find for all models, English versions, but the most important part is underlined and underpinned, and you can see it. And this one is from a German newspaper called Zeit Online. And you see here two options, basically. So you see an option one, where you can basically continue reading. If you click on I consent with tracking and with advertising, and the legal basis is consent. And then you have a second option where you need to conclude a subscription, so a paid a contract. And then there, in this example, there's no tracking and basically no advertising. And then you have a settings option, that's number 3, where you have a granular opt-in and opt-out choices in the second layer, and it looks like this. So you have a consent, you have or opt-out or opt-in. So very granular, very detailed, and independent of this pure subscription model, you have also the possibility, it's not here on the screen, but you can always have a ordinary subscription for the newspaper, and then you get a discount for this pay or consent model. So Tobias, looking at that, and notwithstanding the discussion whether pay or consent is feasible in general, but if you look, if we assume so, this one doesn't look too bad, right? From your point of view. Or what do you say?
So as regulators, we're very careful not to prejudge anything, obviously. So like as a matter of principle, I never say during a webinar whether something looks good or not. But just one observation I'd like to make is that it's important that we kind of distinguish between consent to a particular processing of personal data and whether you see ads or not. Yeah. Because I would say those things are actually a bit different. So you surely could ask someone whether they consent to behavioral advertising or not, but you shouldn't kind of conflate that choice with other choices that will kind of affect the user experience. So we know that consent needs to be specific and unambiguous, right? So therefore it's important not to bundle things together too much. That's one observation I make.
Yeah, I think that's a very critical point, that you should not bundle additional services with the processing of personal data for behavioral advertisement. And that leads us to the next example. You have number 1, also the option to continue reading with tracking and advertising, but this time option 2, you also conclude a subscription, but you only have the exemption from tracking and personal advertising. So there will be, you will be seeing ads, but just contextual advertising, but not behavioral advertising. That's one of the difference. And if you click on privacy here, you have no granular opt-in and opt-out choices you see here on the second layer, but just a transparent information. So that's another version, and it's questionable whether it is so privacy friendly to have no granular choices, but that's something the competent supervisory authority then have to claim. Then there's variant 3, and I think this one we see more and more coming along. There's still the option 1 where you continue reading if you consent with tracking and advertising, but now you also conclude a subscription and it's tracking and ad-free, but you don't conclude this subscription with the publisher or the media house, but there's a third party involved here called Content Pass, and there are several others now on the market as well. So if you conclude a subscription with them, this also applies to all other websites using Content Pass, and obviously the websites that enroll with Content Pass, they receive then a compensation from Content Pass. But this model is deemed, at least that's how they advertise it, that you pay a small fee, a small subscription, but you can use it for several websites and not just one publisher. That's something you see a lot. And then finally, last but not least, an option where you still have the conclusion under 2 of a subscription, but at number 1, there's not consent used, but a contract. This is a phrase that you have to agree to the terms of use and a user's contract. So they phrased it like this. So both options require a contract with the user, and you have no consent at all here. And additionally, that's also something, Tobias, we just talked earlier. Even if you conclude the subscription, it includes not only exemption from tracking and advertising, but also additional features and premium content. So this is something Tobias has mentioned earlier, that here we see a bundling and a mix of processing of personal data, but also premium content and additional features. So in essence, this is what the different pay or consent models are about. And I think after we briefly explained these models, Tobias, let's talk a little bit about the opinions of the supervisory authorities and the underlying issues. Maybe can you guide us through how this pay or consent, how everything started, and it has been discussed in several European member states, and several local supervisory authorities have provided respective guidance over the past couple of years, and now everything is discussed in the EDPB. But maybe you give a short overview how this came along.
No, and I think your overview, Frank, was very interesting because coming from Norway, we don't see these subscription models at all, or we haven't seen them, but we are starting to see them now. So for us, this is actually a quite novel thing, I would say. So what you're showing me is also part of, let's say, my own learning experience. And I think this kind of illustrates why this is coming up now. I think this is an issue that has been somewhat isolated in the sense that it's common practice in some countries in the European Economic Area, but not all of them. Yeah. And another factor is, of course, that this has, I think, been largely limited to the media outlets. Whereas now we're seeing it spread also to social media, streaming platforms, other large online platforms. So this is indeed a change, because now it's going to affect, I think most people within the EU and the EEA. That was not necessarily the case beforehand. Obviously, something that kind of sparked this development was the Bundeskartellamt judgment, which came from the Court of Justice of the European Union last summer. And this was obviously a court case pertaining to Meta and the German Bundeskartellamt, an ongoing case. And the court there kind of mentioned, or let's say flagged, the possibility to impose a fee if someone does not consent. So under data protection law, sometimes you need to have a consent. And where someone, let's say, you shouldn't bundle things together when you ask for consent. So if you ask someone for consent and say, hey, you need to consent to this, whatever that is, in order to access the service, then you should avoid saying, okay, you need to also consent to stuff that isn't necessarily necessary for the service to function. So it's not just, hey, do you consent to us using this data in order to provide the service? Okay, that might be fine. If you're also kind of bundling, and do you also consent to these additional purposes, which are not necessarily part of the service, it's just part of our business model, then that's an issue, and we call that conditionality. And the Court of Justice said essentially, yeah, conditionality, that's not okay. That's a really bad thing. But if you then offer users an alternative, which only kind of where they only need to consent to the parts that are really necessary for the service, then there's no conditionality. And if necessary, you can charge an appropriate fee. So then suddenly this kind of opened the discussion a bit more, because then you have, it's not just the individual data protection authorities in some countries, you now have the Court of Justice of the European Union referencing this possibility. Okay, so then arguably you can't rule it out. You can't say that this is something which is in itself always unlawful, because the court itself flagged this possibility. But then, as we have kind of seen some of the big social media companies, and I would say it's not just Meta, we know that TikTok has also been testing this, and you see other big platforms as well. You also see this kind of being employed for email services. You see it being employed for AI training and data scraping, quite a few use cases. The opponents to this business model are kind of then asking, okay, but is this really a freely given consent, where either I need to kind of consent to everything, including stuff that's not necessary for the service, or I need to pay a fee, and maybe I can't afford to pay a fee, or I don't want to pay a fee, or I would rather pay my utilities bill, my electricity bill with this money. So there is, I say, a lot of tension here. And then you have, again, some authorities in Europe which kind of accepted this in practice. You have some of us who never accepted it in practice, including Norway. It seems that we need to have a harmonized approach in Europe, because the data protection law is the same across borders within all of Europe. And so it's not really a good situation to kind of have this as a lack of clarity. And I think this is what kind of sparked ourselves and Dutch colleagues and Hamburg colleagues to kind of ask the EPB, okay, can you please provide some guidance here? We need to ensure that everyone is on the same page and interpreting this in the same manner.
And yeah, thank you for guiding us through the history of payer consent. And I think it's very crucial that now that some people say Pandora's box has been, opened, that we need at least criteria to work with, because what I think a lot of people misinterpret is the EDPB won't prohibit payer consent in general, because the CGU, it's the last paragraph in its Bundeskartellamt decision, recital 150, but it still said payer K to some extent is possible if you offer an equivalent alternative, right? If necessary, with a price. But obviously, we need now criteria to work with in practice. And I think it's also really important, and thanks for mentioning that we distinguish between different actors or services that now or in future rely on payer K, because I think that also makes a difference when assessing whether consent is valid, or whether the price is appropriate. It also depends on what's the business model, the underlying business model. And I really appreciate that the authorities, at least this time, took a stance from the very beginning and now discuss certain criteria before everything is spread and is a mess. But let's dig a little bit deeper into the details. I mean, as I said, we have pay or pay or consent, and let's start with the consent part. And the key question is whether such consent can be based on a free decision at all, or whether undue pressure situation prevails here. And I just have two very controversial statements that I think illustrate the different opinions here. But maybe, Tobias, in your opinion, what arguments speak against voluntary consent, and maybe what arguments speak in favor of it? So what's the rationale behind this here?
Yeah, I think, as obviously right now I can only speak on behalf of my own authority, the Norwegian DPA, but surely we have kind of done like a mapping exercise internally to kind of understand how the various conditions of consent relate to one another. And so it is, as you referenced, Frank, it is important to remember that, you know, consent needs to be freely given. So you kind of have this business model, which is not illegal per se. Do people really feel in all circumstances that they have a free choice? And arguments against that is that if people feel that there will be negative consequences, maybe they are not really in a position where they feel that they can fully provide a freely given consent. So if they don't consent, what can happen? Well, they will either then need to pay a fee. That is a negative, potentially a negative consequence for them. Let's say that this is something that will affect their personal finances a lot, you know. Arguably, to some people, that could be detrimental. Or let's say that they simply do not have the money. Okay, so what then? They will be excluded from the service, and it's a service that they were no longer, or that they really relied on. That was important to them, to their life. They feel that maybe they are now, you know, blocked from a certain arena in life and society from not participating in that service. So we know that for online services, you know, some of them are more crucial when it comes to, for example, being social or keeping in contact with your family across borders and continents. Some services are more essential when it comes to applying jobs. Some services are more essential when it comes to receiving information. And this is a very Norwegian example, but if you have a child in Norway who kind of let's say you want to keep in touch with the other parents of your child's class, or maybe they have some sports activity that they do. Often this will be any information pertaining to those kind of activities will often be shared in close groups on one specific social media platform. And let's say that now, okay, you don't have the money to pay to not consent, and you're not willing to consent. Okay, so suddenly you can't be on that platform. Your child will suffer because of that. Maybe this is something that will create a detrimental effect to you. But then, sorry,
yeah,
Frank?
please continue. No, please continue. I thought
Okay.
you would pause here.
Yeah, so obviously there, you know, this is something that people have been flagging, you know, is there actually detriment here, or is there kind of a power imbalance that kind of leads people to feel like they can't freely withhold consent? If consent is nudged or pressured, then we also know from other judgments passed down by the Court of Justice that actually that might lead to invalid consent. But companies, on the other hand, are flagging that, okay, but our regulators now asking us to provide our services for free. What's the legal basis for that? You know, which I do understand. It's of course very relevant to discuss here. However, what authorities are looking at are not whether you need to provide your service for free. You can choose to provide it for free and get revenue from ads, or you could choose to charge everyone. That's up to you. That's a business decision. But the question is really whether charging only some users will kind of make them pressured into making a decision that they would otherwise not make. So let's say that, okay, you don't want to consent to us processing your personal data. You have to pay 100 euros a month. Is this something that could pressure people into feeling like they have to consent when this is a service they actually rely on in their lives? I would say arguably yes. Fortunately, we don't see services charging 100 euros a month, but it kind of illustrates that, okay, at some point, at least, there will be kind of maybe be this tension between free choice and the service getting revenue. Frank, you also mentioned previously contextual advertising. I think this is also a bit part of the discussion right now. So because companies are saying, okay, our digital services are actually ad funded, This is how we get our revenue through ads. And then the question is also, okay, so if people don't consent to, let's say, behavioral advertising, are there more privacy friendly alternatives that could be offered instead that would still generate revenue for the service, but that maybe don't require consent so that the user could have more of an option? Maybe it's not as profitable, you know? But how does this kind of fit into the legal discussion? I think this is also very, very interesting to kind of assess.
And you covered a lot, and I think the listeners now see that it's a very, very tricky discussion. And as I mentioned earlier, it goes to the core, to the fundamentals of European data protection law. So although I love discussing, I don't think I want to be in your seat right now, decide on certain criteria. But let's pick some of the arguments you mentioned, and maybe let's start in the very beginning, because I talked to my mom the other day and said, "Look, Mom, I have a webinar tomorrow," and I tried to explain her the model, and she's no legal expert whatsoever. She's the typical data subject and a typical consumer. And then she was like, "It sounds a little bit silly to me." And I was like, "Mom, why does it sound silly to you?" Because she was like, "So there is this digital company that introduced now a data minimalist service that eliminates the tracking for personalized advertising. And now this company is being attacked by data protection NGOs and activists, but also by authorities threatening their decision." And she was like, "So isn't that a misunderstanding?" Then she was like, "Isn't data protection law used against the introduction of a data minimalist business model?" That was her response, and I found it very interesting. So maybe we start with that. If you hear this statement from my mom, how would you respond to that?
I think that's really, really interesting. And I really appreciate this perspective because, of course, we want companies to kind of develop more privacy friendly solutions for sure. But I'm also a bit unsure about to whom do the data pertain? Because if a company is charging me in order to respect my personal data, is this the right outset? Because then it seems like the starting point is almost like, oh, they have a right to take my personal data, which are part of my fundamental rights. And if I don't want that, I am the one that needs to pay. So that's kind of like the opposite perspective, where regulators will kind of say, okay, you can have whatever service you want. You can charge users however you want. There are many different business models. But if you want to use the data service, if you want to use the individual's personal data, then actually they should be in control of that because it's data pertaining to them. It's an integral part of them. How can you charge someone from withholding something which is already an integral part of them and over which they should exercise influence?
Yeah. And I do agree with your thought, but I think and that's in my opinion also one of the core issues here with pay or consent is that there's no legal ownership of data in the meaning of civil law, and how the GDPR is constructed is that you can process personal data as long as you have a legal basis. So if you have a legal basis, and I do not need consent, for example, then I can process the data. Obviously, as the data subject has all the data subject rights, and obviously can try to challenge that. But I think we really must distinguish this fact here. And also, I think the wrong dogma that the GDPR does not permit the treatment of personal data as marketable goods and their valorization. I mean, we have the Digital Content Directive, we have the Data Governance Act, the Data Act. So all these new acts that allow for the monetization of even personal data. So that's something I think we also need to take into account. But you talked about something I want to bring up now, the control of the data subject about their data. And let's get a little bit dogmatic and talk about the legal doctrine here. I think that's very, very essential, because what many critics say here, that there is social justice or social adequacy turn in EU data protection law landscape. So the aim is to turn data protection law, into an instrument that can be used to pursue socio-political goals, social justice, whatever you want to name it. And the question is that the purpose of data protection law? And in my opinion, there's no such protective paradigm beyond empowerment of the data subject, but also intrusion prevention. So if you zoom out, data protection law here in Europe pursues two protection goals, two paradigms that are equal footing. The one is the goal of empowerment of the data subject, so providing control over the personal of your personal data with all the data subject rights, but this includes also the respective transparency obligations, or also the obligation to have a valid legal basis to process data on the one hand. So that's what I call the empowerment paradigm. And on the other hand, the goal of protecting personal spheres of digital privacy against intrusion and harm. So the intrusion or the harm paradigm. And in contrast, the European data protection law does not recognize any further protection paradigms or concerns, in my opinion, such as the protection of the financial interest of market actors, may it be controllers or data subjects, but also the establishment of free access to business services or social justice. So maybe we really, when we talk about whether consent is really given or not, I think the focus should be really what can data protection law provide for and do, and what's something, maybe social security law is supposed to cover. How about your thoughts on that?
Oh, I have a lot of thought. I
Then,
think
then
now
let
we're
us
really
know.
getting into it. I love this. I love this. I think this is excellent. And I think you're posing so many interesting questions here. So first of all, I guess I would have a slightly different perspective on what the purpose and let's say object of data protection law is.
Okay.
So it's not necessarily just about protecting private life and private spheres. It's about ensuring that the processing of personal data does not violate fundamental rights. And fundamental rights is much wider than and much broader than just the right to private life.
Yeah.
It actually goes beyond that. I would agree with you that it's not there to protect the financial interests of people. So again, when I say that companies are free to charge however they want for services, I think that ties in with that. That's a business decision. The GDPR does not charge how much, that does not specify how much you should charge for your service, and DBAs are not price regulators. I would agree there. But also coming back to your point about legal basis, it is absolutely the case that you don't always need consent. it is absolutely the case that that individuals are not always in full control of their personal data, because as a society, we actually depend on processing of personal data. And so we all need to accept that our personal data are being processed, even though we never consented to it and maybe we don't like it. You know, a lot of people maybe don't like that the tax authorities are processing their personal data in order to calculate taxes. But I'm sorry, this is the way it is. You can't change that. And the GDPR does not set out to change that. But if we look at behavioral advertising specifically, the kind of signal we're getting from the Court of Justice of the European Union is that this can actually maybe be beyond the scope of a balancing of interest. It may be beyond the scope of any of the other legal bases, and maybe you actually do need consent for this specific processing activity because it can be very intrusive. And of course, it's a case-by-case assessment, but this is, let's say, the direction of travel here. In some cases, for sure, you do need consent in order to engage in those kind of activities. And so the court is essentially saying, okay, in this particular case, it needs to be up to the data subject, the individual, whether this is something they consent to or not. And again, we're not so concerned with, the business model of the company, how they make the money, how much they charge. We are concerned with whether anything can influence that choice. Because when you are dealing with consent under the GDPR, the law states it needs to be freely given. And you have a number of court cases stating that it needs to be a real choice. So again, it's not about whether you charge for your service, it's whether you leverage the financial position of individuals who do not want to consent in order to make them consent. So it's really a much narrower question than just looking at the financial well-being of people in general. It's about the choice. It's always about the choice, and the standard is it a free choice or not? And I would argue for some services it can be a free choice. If this is a service that you do not depend on at all, I mean, maybe, let's say so. So an example I sometimes use is currency converters. There are many currency converters out there, and I don't think you necessarily depend on a certain currency converter in order to live your life. And if they have a pay or okay model, okay, maybe in that circumstance you do have a free choice, even though there is this, let's say, financial consequence if you do not want to consent. Because there's not necessarily power imbalance. It's not necessarily such that you feel that this is a service that is essential to your life. So I do agree that we need to kind of keep the financial well-being of people outside this discussion, and that it is beyond the remit of data protection. But financial considerations can come into play if they are such to actually influence the user's choice. One thing that we may perhaps have slightly different views on is whether data protection or personal data is a tradable commodity. And again, there's a bit of a tension here because we know that personal data, they actually have a lot of financial value. We know that companies can become amongst the world's greatest and most powerful and richest companies if they have a lot of personal data. This is a perspective that we simply cannot ignore. Yes, obviously you can make money out of personal data. At the same time, data protection is a fundamental right. It's enshrined in the Charter. It's enshrined in other human rights instruments as well. And the EPB has been, I think you referenced this, Frank, the EPB is quite clear in saying that it is not a tradable commodity in the sense that you cannot trade away your data protection rights. Yes, you can consent to personal data, where consent is the legal basis. There are other cases where you don't even are required to consent, but you cannot as such trade away your right to data protection. And this needs to come in as, let's say, an interpreting factor when looking at different use cases and models. I think you referenced, was it the Digital Services Contracts Directive, which has kind of been
Digital Content Directive, yeah.
Yeah, which has kind of been used by in a lot of discussions to kind of illustrate that this is a directive that actually applies regardless of whether you're paying with money or whether you're paying with data. So people are then asking the question, well, surely doesn't that mean that data then is a tradable commodity? It's like a currency, because this directive kind of says that you can pay for services with it. But there's also a recital in that directive. I think it's recital 24. I don't have it in front of me, which also states that this let's say, this definition of the types of contracts that are in scope. It's more about ensuring that the directive has the wide scope. And I think it states explicitly that personal data is not a commodity as such. So again, we see this tension going back and forth. And I think that both sides have valid views. But again, as Data Protection Authority, I would argue that it's not a tradable commodity as such, though it is very much an integral part of the digital economy. How about that?
Fair enough. And maybe before we go now to the pay part, just a few thoughts on that, because I think it's important to mention that you said privacy is or data protection is a fundamental right. No doubt about it, but fundamental rights must be balanced against each other. The CGU, the European Court of Justice, and also the Commission have repeatedly emphasized that the right to data protection is not an absolute right and is subject to limits where it conflicts with other fundamental rights. And we have the right to property, the right to conduct business, the right to private autonomy here. So it must be balanced. That, I think, is something we need to make clear. And the other thing you mentioned is there might be some situations, and I'm at the core, in the beginning, I was an employment lawyer. So I always try to use employment law examples because we are all employees to some extent. So it's very easy to remember. And there are some cases, and you have this imbalance of power in the employment relationship as a core. That's what employment is about. But you have certain situations where you need consent to process personal data. The typical example is pictures and videos on homepages and intranet. You cannot base that on legitimate interest or a contract of the data subject, the employment contract, but you need a consent. And what the practice has done now here is to obtain consent and often use, model contracts. So you get 100 euros as a compensation, and then your face or your video is on the screen, and it's a financial benefit at the costs of privacy. So your personal data will be processed, but you get money for that. And for me, subscription models, it's less data processing, better data protection. So you could also say it's a benefit, so the increase of privacy at a financial loss, so to say. And if we talk about whether people can afford something or whether they want to use it for something else, and whether it's as essential a service, I mean, we also have to pay for electricity or water, for example. And if we cannot pay for that, then it's part of the member state social security system to support. So I think that is also something that needs to be taken into account, whether a social security system is not maybe also something to look here, aside from a data protection. And maybe, Tobias, just give you some examples. When I did research for the webinar here, I found that there is a study from 2021 for the German Federal Consumer Protection Agency. So for our agency that protects the consumer rights. So it's definitely in favor of data subjects, which are often consumers, right? And this paper, this objective study, it calls 2021 to introduce pay models in these kind of services in order to improve data protection, because they say, on the one hand, it allows users to switch to data minimalist offers and provide them with a choice and a gain in digital autonomy. And on the other hand, and I think that's an important aspect, it also makes it clear to the users that the free of charge alternative has also a price. And there's also a paper from our Data Ethics Commission. It has been established by the government, and even prior to to the study I mentioned just now, 2019, they concluded and discussed payment models for such services and came to the conclusion that an alternative model of monetary payment can be an ethically acceptable solution for ensuring the voluntariness of paying with data for a service if the price is not abusive and a realistic alternative to the provision of the personal data from the perspective of the consumer. So there have been other agencies or commissions, at least here in Germany, and I'm sure in other countries as well, that talked about the ethical aspect and the fundamental rights aspect, and they concluded it's actually something you should pursue because it empowers the data subject. So I think that's at least worth to mention. But let's we talked about costs and fees. So let's go to the pay aspect now, and you see now the very infamous paragraph also from the CTU here that people say, okay, the CTU allowed for payer consent models because it said here that you need to provide for an equivalent alternative if necessary for an appropriate fee. And then the question obviously is what constitutes appropriate fee and who to determine that fee. And we mentioned a lot of acts already, and I think that's also worthwhile to conclude and mention here. It's not just data protection. We have e-privacy, where you also need consent if you use cookies or other tracking mechanisms to access information or store information on a user's device. We have the Digital Services Act, we have the Digital Markets Act, we have the Digital Content Directive you just talked about, and the Commission, for example, has also recently initiated an inquiry into payer consent models under the Digital Markets Act. So I think we have a lot of different regulation, and it's not just data protection, but you are the data protection authority now, and in order to determine a price, I mean, it's difficult for a data protection authority, right? And when I spoke to Thomas Fuchs, who is the head of the Hamburg Supervisory Authority, who also joined your initiative in the EDPB, Thomas Fuchs mentioned then that for the proceedings he had on the subject, he consulted with the German Federal Cartel Office in terms of price, so the Bundeskartellamt, that was also subject to the CGU decision to determine, what's a fair price or not. And I think that's essential going forward. Is that something that is also being discussed in the EDPB, and has the EDPB consulted competition authorities in order to determine certain criteria for a fair price? So maybe you can give us some glimpse here, and what's your take is on the requirement of consulting with other authorities in determining a fair price.
Yeah, which is also a very interesting point. I think that, first of all, the EPB is leaving no stone unturned here. So, of course, data protection authorities are engaging with both competition authorities and consumer authorities. If anyone is worried that we are not, you can rest assured we very much are. But sometimes I see people referring to competition authorities along the lines of, well, DPA should not set the price, so they should kind of refer this assessment to competition authorities. Well, first of all, competition authorities are not competent for enforcing the GDPR. They might use it, but they're not responsible for enforcing it. So we can't, outsource our own assessments. But also competition authorities are also not price regulators. I don't think any of these authorities are keen to become price regulators either. So this is not really what it's about. I think, and you also mentioned this, Frank, about, could there be cases where users are actually empowered? I personally struggle a bit perhaps to see that, but I think the general point is that if companies can show that users are really given a freely choice, then it's no issue because then the choice is really given. If data protection authority says, well, okay, can we ask some of your customers? And they say, yeah, it's a free choice. I felt I had a free choice. If companies can really show that users have a free choice, then it wouldn't be an issue. And I think this can also be a bit a starting point for assessing the appropriateness of the fee. First of all, whether it's appropriate to have a fee, whether, what the size of the or amount of the fee should be. I think it is for the companies to kind of carry out that assessment themselves. So if they are in a position where they believe that they can validly employ a pay or pay model, then it's also first and foremost for them to kind of decide what is the appropriate fee. The Norwegian DPA view would at least be that that is the case. But then what is then the role of data protection authorities? Well, as always, our role is actually seeing whether there is a freedom of choice or not for users. So what we could say is, again, let's have the extreme example of someone charging 100 euros a month. 100 euros, that's a lot of money. Maybe in that case, regulators will say, okay, we don't fully understand how you kind of reach the understanding that this was appropriate. We don't understand how we can say that this does not influence users' choice. Provide more information. Maybe you need to do a new assessment. Maybe you need to provide some more documentation. It all kind of boils down to accountability. So again, not DPAs becoming price regulators, but DPAs asking companies, okay, can you actually document in line with the accountability principle of the GDPR that this fee is such that it is appropriate given the circumstances and not pressuring people or nudging people to consent. That is the legal standard that we're concerned with. And again, it's not about, whether they generally can charge users or what their business model is. And I think you mentioned also the right to conduct a business here, which is obviously very interesting. This is also something that is enshrined in the Charter. And Frank, you're absolutely correct in saying that data protection is not an absolute right. It should be balanced against other rights. But if you look at the right to conduct a business in the Charter, Article 16, it actually says that the right to conduct a business is respected, and the right to conduct a business in compliance with the law, EU law, member state law. So obviously you do need to comply with the GDPR. You can't say that, oh, I have a right to conduct a business and therefore I don't need to comply with this cumbersome provision of the GDPR. You do need to do that. But I think that everyone here, including DPAs, are kind of very mindful of what is data protection law. It's whether consent is freely given. If the law says that this is something you need a freely given consent to do, it really needs to be freely given. But if we're not in that sphere, then some things are pertaining to business decisions that is not always what DPAs will be looking into. There needs to be this link with freely given consent, and that's accountability. If we're not in that sphere, then it's a business decision.
Yeah, and you mentioned some, and I do agree with most of the parts you said, and you also mentioned this empowerment again, and maybe I think it's also very crucial for the price, because I just cited what the Data Ethics Commission said 2019 already. And it's similar what the CGU said in the Bundeskartellamt decision. So a pay model cannot entail a general choice and empowerment if the price demanded is so high. But I think that's the crucial factor, that it is beyond the financial capacity of the average user. I think that needs to be taken into account to make a difference between the data subject's financial ability and what we call in economics the willingness to pay, for the reasons of preference. Just because I subjectively find the amount too high, although I could afford it, don't want to pay for it, and that's why the consent is not freely given. I think we need to distinguish here, because the empowering effect of a pay model, by pointing out that people prefer to spend their money differently, that's the realization of preferences, and it's an expression of the exercise digital autonomy, and not a curtailment of it. So I think there's a cognitive or logical bias here, and I think we also need to look into from a data protection point of view, so from a legal methodology again, when we talk about equivalence, the equivalence criterion, and appropriateness of a price, that needs to be made on the basis of the interests of this EU citizen as a data subject, compared to the interests of the EU citizen as a market citizen with financial interest. And I think that's outside the scope of data protection. But then again, we have the typical privacy paradox here that we see in the online realm, that people dislike being targeted by advertising, and dislike that their data is collected based on their activities, but at the same time are unwilling to pay for ad-free services. So that's the privacy paradox. I think that's very tricky. Maybe we talked a lot about consent, because I think that's the core data protection issues. We talked for about 50 minutes about the price. Maybe continue in the end, being cautious about time, a little bit about what's lying ahead of us, and what you in the EDPB are currently doing. I know you are not allowed to share any concrete details, but what are maybe some of the stumbling blocks, or what is currently the subject of the very heated debate within the EDPB itself? And I mean, you have the deadline until early May for the decision. Might we see it even a little bit sooner? I think next week are plenary discussions. So maybe you can give some information here that you are allowed to provide, obviously.
So just a bit of housekeeping rules. Just kind of, I'm sorry, Frank, I have to say this. So the slide was currently on the screen. I think that reflects your views. It does not reflect my view. It's not a takeaway from my point of view. And as you also referenced, I can't actually speak to what is in the EDPB decision or opinion, sorry, which is not yet finalized. It's not been adopted, and it's not finalized until it's adopted. So obviously discussions are still ongoing. What I would say in relation to the EDPB opinion, and I think actually a spokesperson from the EDPB was quoted publicly saying that there is an aim to hopefully adopt this a bit sooner than the deadline, hopefully towards the middle of this month. And we'll have to see whether this aim will be realized or not. That's not for me to say. But so we could see this coming out essentially at any point over the next coming weeks. I think it will kind of explain a bit more about how the various conditions for freely given consent, how they relate to one another, and sort of provide some more substance in terms of how to assess pay or okay models and whether they are lawful or not. I think you mentioned, Frank, the need for some criteria here, and the EDPB is indeed very mindful of this need. And I think it will provide, however it ends up looking in the end, I think it will provide some clarification here in terms of what are we really dealing with, and for example, the difference between what is a consumer choice and what is consent under GDPR, consent being a very strict legal standard, but what does it really entail? How does it fit in with, or rather, how do the statements of the court fit in with what the EPP has said previously about consent? What is the way forward? I think it will provide a lot of clarity here to the discussion and really set out what data protection authorities are expecting. So hopefully it will be informative. I think it will be exciting to see how people respond to it, however it will end up looking.
Thanks for at least sharing these details. And I think what we also need to explain to the listeners that there are, several streams here, right? We have this binding decision on the very particular meta case at hand, right? But it's not just as we learned, social media service providers. We have publishers. We have, as you mentioned before, we have a lot of other controllers that now make use of this payer consent model. And I think, and I don't know whether you can share this information, but aside from this binding decision, I guess there's a need of a EDPB guidance on this topic, right? So I would assume that after this decision has been made, you will also be working on certain guidelines where you have more time to elaborate on certain aspects, right? You don't have a legal deadline here, but also can go more into detail. Is that something that we can also be looking forward to?
I think this is what a lot of DPAs are hoping for as well. So obviously I can't predict the future, but I think that this would be a very sensible next step. And I think other DPAs would also share that. So hopefully this is something that will materialize as well.
Awesome. I mean, now we've reached the end, and I think as the listeners could see, we could talk forever about this topic. Thanks a lot, Tobias, for taking your time talking about. I think all the viewers, all the listeners have realized a very, very complex, hot, controversial topic, and we had one of the key people dealing with this topic for a long time, and maybe also for a long time in the past, but also for quite a while in the future. Thanks again, Tobias, for joining us, providing valuable insights, also your points of view. I do agree with certain things you said, but as a also legal professional, I also look at the law and the legal doctrine, and I think there we might see a little bit of differences, but I think we can all be very curious about what you guys come along in the EDPB, and maybe we have a chance to talk once the decision has been made, and then go a little bit into the details about your decisions. I wish you a very lovely afternoon also to you, listeners. Tune up for the next DataGuard masterclass, and as always, and our mission here at DataGuard, let's try to protect the people behind the data. All the best. Cheers.
Bye.